Within seconds, multiple matches appear. A sanctioned individual, a politically exposed person, similar names, different countries. What does this mean for you? Are you legally exposed? Do you need to report it? Or is this simply a false positive? In sanctions and PEP screening, overreaction creates as many problems as inaction. Let's clarify what you are actually required to do. Sanctions screening checks whether your client appears on an official government sanctions list, such as Australia's Consolidated Sanctions List. If a person or entity is designated under Australian sanctions law, dealing with them can constitute a criminal offence. That is serious. A politically exposed person, or PEP, is different. A PEP is not someone suspected of wrongdoing. It is someone who holds a prominent public position, such as a senior politician, judge, military official, or executive of a state-owned enterprise. The issue with PEPs is elevated corruption risk, not illegality. That distinction matters. Australia's AML and CTF framework is risk-based. You are not required to apply maximum screening intensity to every client in every circumstance. Your obligations depend on the nature of your service, your client risk profile, geographic exposure, and the overall risk assessment set out in your AML and CTF program. Sanctions exposure must be identified and managed. PEPs require enhanced scrutiny, not automatic rejection. Screening is not about suspicion, it is about proportionality. Your AML and CTF program should clearly explain when screening is conducted, when enhanced due diligence applies, how potential matches are assessed, and how decisions are documented. Compliance is not about collecting alerts, it is about making defensible decisions. Most screening alerts are false positives. Common names generate multiple matches. For example, searching John Smith may produce results across different countries, with different dates of birth and completely unrelated occupations. A name match alone does not establish identity. Your obligation is to assess the match, not panic. You consider date of birth, nationality, known addresses, occupation, and other identifying information. If the alert clearly relates to a different individual, document your reasoning and proceed appropriately. A screening result does not automatically require a suspicious matter report. Judgment remains central. Flagship AML integrates screening data from open sanctions to assist your risk assessment. You can conduct sanctions and PEP searches during initial onboarding within your due diligence workflow, or directly from your user dashboard. The screening tool supports your analysis. It does not replace it. Flagship AML does not encourage unnecessary overscreening. It is designed to support a structured, documented, risk-based approach consistent with Australian AML and CTF obligations. Screen when required, escalate when justified, document always. Sanctions and PEP checks are powerful tools. Used correctly, they protect your business. Used incorrectly, they create noise, delay, and unnecessary fear. Understand the obligation, apply judgment, document your reasoning. For structured, practical compliance tools, visit flagshipaml.com.au.